Recording the webinar, okay, and we're gonna go live right now.
All right.
No, you're good. Okay, it actually says that we're live. It says setting up live. Okay, we're good. Okay, so okay, it says to me that we're live. Does it say we're live? Yes, we are. Hey everybody, Leticia here, coming to you this Thursday afternoon, August the 20th, for another edition of my weekly Money Matters webinar series. And today's topic, as you may have seen yesterday, is the topic of wills and powers of attorney. Why do we need these documents? What's the deal with, do I really need a will? And what happens when you don't have a will? And this is a topic that I think is particularly relevant to people, especially now during these uncertain times that we're going through. And with me, joining me today, I have Mr. Jack Zwicker. Jack is a very experienced lawyer with a 40-year career in corporate property, estate, and employment law, and real estate as well. We said property. And Jack, in recent years, has been primarily focusing on mediation and arbitration, including in the corporate sector. So if any of you have those types of needs, he can definitely assist you with that as well. And like me, because of the uncertain times that we've been living with, Jack is finding that more and more of his clients are asking about wills and estates planning. So he's agreed to join us today to bring some light to this topic and really educate us, our audience, my audience, you guys, as to why these documents are important, what happens if you don't have them and something bad happens, and you know, what is the importance, what kind of role do they serve? Jack has put together a few slides for us. So first of all, without further ado, welcome, Jack.
Thank you.
Thanks for joining us. Any starting words on this topic, by the way, Jack?
Well, that's basically what I'm going to be dealing with over the hour. I've split the presentation into two. More of it is wills than powers of attorney, but I'm going to cover both. I'll do a little bit of sort of history so you know where this stuff came from, and then a lot of it will be very point oriented. It'll be functional so that you know exactly what it is that lawyers do and why we do it.
Wonderful. Thank you so much. So would you like me to start going through the slides, Jack?
Yeah, if you can, and then I'll follow your lead.
Absolutely. So I know you have some stuff about putting together a will. Do we want to talk about even what a will is, in case anybody out there doesn't know what a will is?
That's a great idea. That's where I'm going to start.
Okay.
I'm going to start with a little bit of a history lesson. My undergrad work, which I really never left behind, was in joint honors history, political science. I've always loved history and I've always loved government. And then I switched to law, and I've been a lawyer for into now 44 years. So I'm going to go back to my, my old stuff, which is my history background. If you were to clock back 1,020 years to the year 1000, there would be no wills. And I'm talking now Western Europe. North America, of course, was not populated. The native people were here, but the Europeans had not come yet, right?
Yeah.
They didn't come until the 15th century. So if you clock back about 1,020 years, and if somebody said, you really need to make a will, no matter what language they were speaking, they'd look at you wondering what you were talking about. Right. Two reasons. One reason is that the vast majority of the population back then, we're talking Europe. I'm not dealing with the East, I'm talking about Western Europe. Although this may well apply elsewhere too, did not read or write. Literacy was a very scarce commodity. The other thing is access to paper in any kind of modern form was not really there either. So because it was hard to write something down and people didn't read or write, there was no point to having a will. As technology improved and paper resources became more available and there was an increase in literacy levels, suddenly wills come into being. And very often what the law does is it recognizes reality by having governments pass laws when there's a need to be filled. So
when there's a need, Jack, you know what, your volume is coming a bit low.
I'll push forward a little bit. Yeah, unfortunately we had trouble adjusting the volume. Is that better?
Yeah, but now your face is like super close to the screen.
Well, yeah, all right. I'll just yell. That'll take care of it.
If you could adjust your volume a little bit.
Yeah, I can't. It's just not working.
Yes, so I know. You're good. You're good.
Yeah. All right. So what winds up happening is this. At some point, more probably maybe 1600, 1500, 1600, wills started becoming something that could be done. People would write what they wanted to do. And the purpose of a will basically is to provide a map for the people who survive you. And I'm going to use Ma and Pa as an example. It's the easiest way. Mother and a father, husband, wife. We're not here forever. And we can't come back from the grave and we can't tell people do this or do that, all right? Because we're dead. So the only way of trying to make sure that our instructions when we're alive are carried through to somebody after we're dead is by writing them down on a piece of paper.
Yeah.
That's what a will is. It's not any more complicated than that. The laws as they were created in Europe, and we have different legal systems, so it really doesn't matter too much who has what, but the legal systems in Europe and then North America essentially allowed for laws to be passed. They're called statutes. In Canada, we have federal laws and we have provincial laws. We're a federation. The whole area of estates, wills, powers of attorney is provincial. It has nothing to do with Ottawa. Each province has its own rules. They're pretty much the same, but they all have their own rules. And one of the statutes that we have, and it'll be picked up later in my slides, but I'm just going to mention it now, is an act called the Succession Law Reform Act. And that creates the model for will making. It tells you what a will has to look like. It doesn't give you the details as to what goes in it, but just the model for the will, what it looks like, what names have to be identified, the need for signatures, the need for witnesses, that kind of thing.
So does that bring us to this slide here, Jack, as to who we want to name as some of the parties?
Having said that, that's sort of the legal background to what I'm about to talk about. The slide that we're looking at is will basics, and there are 4 points on it. The first one, and you can read it for yourself, but the first one is, if you're going to have a will, for one thing, you have to identify who you are. If I were making a will for myself, it would say, it would mention that this is the last will and testament of Jack Zwicker. That's my name. And I would indicate what city I live in. I'm of the city of Markham in the regional municipality of York. And then ahead of the first point, which is naming an estate trustee, it would actually have something, and all wills do this, it would have a simple clause saying, I revoke any prior will. Because it could be, although a lot of people run through life, they don't make wills and they leave a mess afterward. It could be that you have a previous will, and by law, your most recent will gets rid of your older will.
Okay.
So by law, if I do a will today, and I had a will from 5 years ago, the today kills the 5 years ago will. Okay? That's by law. But just to make, it's like putting a little cement on it, just to make sure that, you know, everything is safe. All lawyers do this. The very first paragraph after identifying who the person is making the will, it will say, I revoke any previous wills. Okay.
That makes sense.
Yeah. So that just makes sure any of this old stuff is gone and there's no confusion between the will today and a will from 10 years ago or a week ago.
Okay.
Generally speaking, this is not in the slide, but generally speaking, people do update wills. They don't do it all the time. I mean, I had a client years ago who would call me every year, always the same month. It didn't matter what month it was. Should I come in and update my will? And I never like taking money for nothing from clients. I just don't operate that way. It's not the way I'm wired. And I said, has there been a major change, either of your trustees, which we'll talk about in 2 seconds, or your beneficiaries, or your spouse? You know, are you divorced now? No.
Yeah.
Is everything the same? I said, so then why waste money and time in my office making up a new will? What's the point? Which wasn't good for me, but it was good for them.
That's
Sorry?
What a proactive client. That's the opposite of most people.
Yeah.
Most people
I wish all of my clients were like that. I would have made a lot more money, but you know, you have to be honest and you don't waste their money and their time and your time creating nonsense. If they're okay, they're okay. Leave it as it is. Right?
Absolutely. Yeah.
So what would happen then, assuming if somebody comes in and says, look, I last made a will 25 years ago. Back then I wasn't married. I didn't have any kids. I've had a falling out with some of my friends who might be executors. The minute I sort of smell there's a fact change that's important, I will say, let's come in, let's discuss it. And the key is, if you're making a will, the very first thing you have to do is you have to name at least one estate trustee. The trustee, I know that's fancy.
Explain to us what that means, because that sounds like a buzzword to a lot of people.
Yeah, it is. Okay. At
Okay.
one time, the word that we used was executor. Some people may know that word.
That's the word. Yeah, that's the one I'm used to hearing more. Yeah. Okay.
Yeah.
It's one of the same.
What happens is lawyers get cute, and every so often they decide that they're going to change the language, which is okay for us because as lawyers we know this stuff.
Yeah.
It leaves the rest of the world behind because they don't know this stuff.
Okay.
And they start fiddling with the language and they sort of change the words around, but it's different words, same meaning.
Okay.
Executor, state trustee, same jazz. Same
okay.
stuff.
Okay.
So you have to name at least one.
So tell us what this person is supposed to do, if you don't mind.
That's what their duties are. But before I get to that, the second one is name at least one alternate trustee. Why? Let's say the person you chose or you choose as your trustee dies before you do. You don't have anybody.
Yeah.
So you'll always need an alternate. Is just fancy language for a backup.
Yeah.
You gotta have a backup. Now, do you have to do that? No. Should you? Yeah, it's smart to, because don't take chances. You don't want to keep running back to a lawyer's office, because you miss things along the way. Now, what does the estate trustee do? In a sentence, he does exactly what you would do to look after your property while you're alive.
Okay.
Okay. Once you're dead, you're dead. You can't look after anything.
Yeah.
Your trustee takes over exactly what you would have done if you were alive. Now, what could that be? It could be buying property, could be selling property, could be mortgaging property. Any of the things you could do if you were alive, your trustee has the same functions.
Okay.
It's not that complicated, right? So that's essentially what the functions are. One of the other functions of trustees or estate trustees is in estate administration. When somebody dies, everybody has assets and they have liabilities.
Mm-hmm.
If you've had a good life, hopefully your assets are a lot more than your liabilities. Right?
Yeah.
And I'll get to insurance after. I'm going to throw that in as well, but that's a little different because it
bypasses.
throws a bit of a curve in what I'm doing.
Yeah.
But hopefully, if you do well, you're going to accumulate all kinds of assets. Typical couple, and I'm going to do ma and pa because I think that's easier for people at the more basic level.
Yep.
Ma and pa, first of all, let's assume they are legally married. They may not be. You're getting a lot more common law relationships than you.
And we're going to talk about that and how that affects things.
Because it's very different. It's very different if you're not legally married. But for now, legally married. Mm-hmm. So ma and pa, let's say, scrape together enough money and they have enough of a mortgage and they go buy a home to live in. Okay? Their principal residence. And maybe they have some kids. Maybe they really do well and they buy a cottage. And once they have kids, they start looking at their assets and maybe they have some debt as well, because very seldom does somebody have all assets and no debts, no liability.
For sure, yeah.
And they say, God forbid if something went wrong, we might need to buy some insurance. Not so much for ourselves, but maybe just to pay off income tax later on, because that's one of the main uses for insurance. There's different kinds, right?
Yeah.
They may have insurance policies. They may, and very likely will, unless they sleep with their money under their mattress, they're going to have a bank. They're going to have a bank.
Investments.
They may have joint accounts, ma and pa together, or they may have separate accounts. Depends how they organize their lives, but they're going to have bank accounts. If they really do well, they may be invested in the stock market. They may have bought stocks or bonds, and they're going to have somebody looking after that for them. They may have an account manager rather than they do it themselves, right? Again, it's whatever they choose to do. Mm-hmm. All of those assets and all of the debts that they accumulate are part of what accountants would call a balance sheet. It's like an asset liability sheet. It's a balance sheet. When somebody dies, all of that falls into a thing. It's not a real thing. It's a fiction called an estate. So a person's estate is the sum total of all of their assets minus all of their debts. That's what your estate is.
Got it.
All right.
Thank you for clarifying that for everyone.
The duty of a trustee is to administer all that. And the principle is, there's two parts to the principle, is the debts get paid off first, and then what's left over go to the beneficiaries.
Okay.
Okay. So debts have to be cleared out first. What are the debts? Typically, debts would be things like income taxes that are owed.
Mhm.
They would be things like funeral expenses.
Sure. Yeah.
It would be things like mortgages on property. If you buy land or you buy a building and it has a mortgage
Yeah.
and you want to get rid of it, you know, it's not free. You got to get rid of
What if it's Jack? You know what? A lot of the people in my network are real estate investors, so they
it.
they often have multiple mortgages on multiple properties.
Right.
And you just mentioned to me that debts would have to be paid off. Is it
Well,
absolutely necessary that they get paid off? Because
not immediately, but at some point, yes, they'd have to be paid off. The term
what
of
if those?
the term of the mortgage would indicate what the term is. Okay, like people
Yeah.
buy, if they get a mortgage, if it's a purchase money mortgage, let's say a 1 year, a 3 year, a 5 year,
Yeah.
they work with that.
Yeah.
Now, the only thing is that banks are, I don't want to get too far off or it's going to confuse people. I want to stick to the text, but
Yeah.
banks like to be kept apprised of the fact if ownership is changing.
For sure.
When you take a mortgage from a bank, this is not a real estate course, I don't want to get diverted with it, but if you take a mortgage from a bank and then the owners of the property are changing, somebody died, bank's going to want to know that.
Yeah.
All right.
Fair enough. Yeah.
Because ultimately, the people who will inherit that property will be someone else. It may not be the person who signed the mortgage.
Yeah.
So the bank does that, has the right to know what's going on. You can't keep secrets from banks, all right?
Unless it's corporate ownership, in which case the entity that owns the property hasn't yet.
Well, that's different. If it's a corporation is a person in law, not a human person, but a fiction person,
Yeah.
right? So they are a person in law, whereas a person, when they're dead, they're gone. Right?
Mm-hmm.
So there could be an issue where a bank may say, we want our money. Right?
Yeah.
Here's the problem.
Interesting.
And this flips back to Letitia and part of what she does is that if the assets are all tied up in tough stuff, okay, no insurance, no cash, right?
Yeah.
How do you just pay a mortgage off on 2 seconds notice? It'd be very difficult. That's where some people will use insurance and say, I don't want to sell the property now.
Yeah.
I don't mind paying off the mortgage, but I don't want to have to sell the property to pay off the mortgage.
Yeah.
Okay. So I'll use insurance to do that. That's
life insurance can provide
greatest uses of insurance is
liquidity. That's right.
Not so much getting money to your kids, right?
Yeah.
But just to come back to the will basics.
Yeah.
So the person who's making the will has to name himself, has to name at least one trustee, because somebody's got to do the work, and preferably at least one alternate. Okay, in case the main trustee dies first, you got to have a backup.
Yeah.
All right. And then the business of paying off the bills and the debts is the first responsibility of a trustee. Nobody gets anything, none of the kids, no wife, no husband, it's the debts first. That's the first thing.
Okay.
Now, one thing, and it's not in here because I didn't want to make a lecture out of it, one of the things that happens is under estate administration law, there's something referred to as the executor's year. Today, the language would be estate trustee's year. Different language, same jazz, right?
Yeah.
It's not a law that says you must administer the estate within 1 year. It's recommended that you do it.
Okay.
You're not obligated as a trustee to do that. It's basically a touchstone. Try to get it done. Some estates are very complicated and there's a lot of work that has to be done, which I'm not going to get into today. And it could take a number of years to actually get administration done, including hiring chartered accountants who are tax people to do all the tax filings for the individual, in the year they died and following the estate returns. It's very complicated stuff. It's not for individuals to do on their own.
That's right.
They're not going to, A, they won't even know they have to do it, and B, they won't know how to do it, right? They've got to have a very good accountant who's a tax expert doing this stuff.
But it would be the executor's job to hire that accountant, correct?
Exactly.
And you can name, if you have a, let's say a law firm an accounting firm that you've been working with already, you could potentially name those guys as your preferred accountants, correct?
You could recommend it, but ultimately, here's the problem, that when the person dies, they die. And it could be that the estate trustee knows of someone else who they think actually is better at it, and they don't want to be tied up. They don't want handcuffs on them saying you can't this and you can't that. Or the person who's died is tying up the, the estate. They're making the lives difficult for
Okay.
the estate trustees. So I don't recommend that. Usually the clauses that we use will be clauses that say, especially if it's a complicated estate, that the estate trustee will have the right to designate valuers if you need a property valuation, chartered accountants, this kind of thing.
Got it.
So that
Got
you
it.
leave it to the estate trustees, let them get the people. Okay?
Yeah.
They're
Makes
like
sense.
the chairman of the board, but they don't do all the work themselves.
Yeah.
They go hire people to
Yeah.
do it. Safer. And we have clauses for that. In a ma and pa will, don't really bother too much, right? In a more
Yeah.
complex will, where people have a lot of property and they may have shares in corporations, whatever, we tend to knit that stuff in. So we have to flex it depending on what we're dealing with.
Got it.
What the level of assets and sophistication of the client.
Got it. Okay.
Okay.
Let's keep going, Jack, because I know we're
All
only
right,
on
yeah.
slide one, and
Okay.
yeah.
Now we've covered all that off, so we're done with the first
The
one, which is will
beneficiaries.
basics.
Yeah, we name at least one beneficiary. So I guess once the debts are paid off,
Well,
is
then the trustees or trustee is ready to start transferring to the beneficiaries.
okay.
Who are the beneficiaries? Ma and pa. Husband, the wife is usually the beneficiary. Doesn't have to be, but usually. The wife in a separate will, okay, will leave to the husband. And they do separate wills or separate documents. We don't have what some countries do. I had some South African clients probably 10 or 15 years ago who came to me and said, why can't we do a joint will? Meaning ma and pa, one piece of paper. I don't mean one piece of paper, but one document, one will, right? And I said, we don't do that. I was aware that in South Africa they do. I said, we don't do that. Each person makes his or her own will, period. That's it. No exceptions. But they can mirror each other, and they usually do. Usually it's mirror image, but it's two separate documents, not one.
Yeah.
Okay. So let's say the husband leaves his estate to his wife and hers. The wife will leave her estate to the husband. Once they're both gone, then the kids get into the routine. Okay. If you have only one child, well, that's easy. Okay, there's no conflict involved. If you have more than one child, one of the things that ma and pa have to do is they have to decide what shares are going to go to these kids. In I shouldn't say good families, but in families that are not dysfunctional, they're not having, problems along the way, known as rotten son or rotten daughter or whatever. Generally, equality is the principle.
Yeah.
If you have 2 children, 50-50 to the kids. If you have 3 children, a third, and a third.
Yeah.
Then you get your tough cases, and I've had my share of those as well, where there's a relationship problem. Could be the children don't get along, or it could be a child and a parent doesn't get along. And some of the really rough ones are a child is estranged from a parent or parents, and they haven't talked to them in 20 years.
Wow.
Okay? I mean, it's some really horrible situations.
Jeez.
And then it's up to ma and pa to decide, am I leaving anything for that child who doesn't even know who I am anymore?
That is a tough situation because,
and if so, a reduced share, or do I cut them out completely? And
wow.
The law in Ontario, and it's the law everywhere, it's not just here. The law in Ontario is that if you have a child who's of the age of majority, so age of majority is 18 or more.
Okay.
And if you don't want to leave anything to that child, you don't have to.
Okay.
Now, they may sue afterward. They may try to upset the estate and, litigate, but you're not obligated to support adults. You're obligated to support minor children.
Interesting.
The age of 18. And I've covered that where I've made a reference to children under the age of 18.
Yeah, we didn't talk, included okay. Yeah, makes sense. Equal or unequal shares. So that's a good point you're making. So if the children are under 18, you're under no obligation to even leave them anything if you don't want to.
It's safer to leave them something because they may come back and attack the will. And of course, ma and pa would be dead by then.
Yeah.
So then what happens is it's all the children fighting amongst one another about who gets what, right?
Then
but I don't want to get into that today because we don't.
No, like that's the area of estate litigation, and that's what we're trying to avoid actually by doing a will. Yeah, we're trying to bring clarity to the situation so that everything's clear, everybody's happy, and no infighting.
It's safer to leave something than to leave nothing.
Yeah, for sure.
Somebody may not want to, and they don't have to. So let's leave that aside. I'm just dangling that so people watching can sort of think about it and whatnot.
Yeah, thanks, Jack. So speaking of somebody that has children under 18, you're saying that there is some sort of obligation or responsibility. How does that work?
Okay, I mentioned at the beginning, and I picked it up at the very end, we're not there yet, that we have an act in Ontario called the Succession Law Reform Act.
Yeah.
That imposes an obligation on parents to look after their minor children. But once they're not minors anymore, you know what? Do what you want.
Okay.
Okay.
So in that case,
there's also obligations of husbands to look after wives, right?
Wow.
Now, the hook, and I don't want to get too complicated, but the hook on this is spouses have to be legally married spouses, not common law. I mentioned that in passing. I'm coming back to it now.
Yep.
There is nothing to protect a common law spouse if he or she is cut out of a will, or if they just don't make any wills and they're common law when they die.
Right.
There's no protection there for them.
So are we talking later in a later slide, Jack, about what happens if somebody passes away without a will in Ontario?
We will.
Oh, so we're going to talk about that.
I'll come back to it, but
that's an area that becomes even more important for people who are not legally married. So if you're in a common law relationship and you pass away without a will, your common law spouse can get zip nada.
Or to use another expression out of some of the movies, forget about it, right?
Okay. Yeah. So it's extremely important, especially for people, because the law does provide some sort of protection to married spouses.
Correct.
And we're going to talk about what that is.
I'll come back.
But that protection is not provided for common law spouses. And I think, again, myself, I'm a single parent.
Yeah.
I think that a situation like mine is even more complicated because, well, what I had to do, Jack, speaking of minor children, I had to name a, oh my gosh, what's the word? A guardian for my child. Yeah. And then a backup guardian, again, just like we talked about naming the estate trustee, also known as the executor. Beneficiary would be my son, but he's a minor. Therefore, I had to name a guardian. So somebody
has to look after him until he reaches the age of 18. So I'll come back to that though.
Okay, are we talking about the guardian? Okay, so we speak about okay.
Okay, so the next checklist is will basics. There's a whole bunch there.
Yeah.
So I mentioned at the beginning, when people are named, whoever they are, it has to be their full name, not nicknames. Their name, their regular name.
Yeah.
And the city they live. So in my case, my name is Jack Zwicker, and I'm of the city of Markham.
Okay. No, it does raise a question, Jack. What happens if somebody moves? Let's say I'm a Canadian, I live in Ontario, I decide to move to Quebec or somewhere else.
Doesn't matter. You're still you.
And a Canadian will be valid, because you mentioned that the different provinces have slightly different processes in terms of setting up the will.
Okay.
But a Canadian will made in Ontario is also valid anywhere in Canada.
Yes, that's true.
So if that Canadian,
the only province that's a little different is Quebec, which is my home province. I'm an ex-Montrealer. In the province of Quebec, they have a civil code system very much like the civil codes of Europe, France, Germany, Italy, Spain, whatever, right? So in civil jurisdictions like Quebec, they have something, the French expression for it is le code civil, which is the civil code. And they don't have individual laws or statutes like in Ontario and the other 8 provinces that are common law. But forget about that, because it's just going to keep
let's not complicate. So in other words, if somebody lives in Quebec,
the bottom line is this: if you make a will here in Ontario, all right, it's fine anywhere else. Don't worry about it.
Okay. What if the person
wills coming in from other jurisdictions are also fine. We recognize each other's stuff.
What happens with I don't know, somebody that decides to move back? Because I mean, Canada is a country of immigrants. If they move back to their homeland, I guess the Canadian will apply for the estate in Canada.
It can, and often what happens with people like that, where they're moving back and forth, is they may see a lawyer in the jurisdiction they've gone back to, wherever it is, and that lawyer will say, "Let's do a will for that jurisdiction."
Absolutely, that makes sense.
They have 2 sets of wills that are operating. We'll call it the foreign will and the Canadian will.
That makes sense.
That's common. That's common.
That makes sense.
Yeah.
That brings up a lot of questions, including questions about like property held overseas. Do you even declare it on the Canadian will? I don't know. You don't have to.
I don't, because my practice, I don't list specific assets. Okay, a will's not an encyclopedia. Okay, you don't want 300 pages to a will unless you want to pay some crazy fees. So
Okay.
what you're doing is you're basically referring to property, all the property I own.
Okay.
You don't say this house and that cottage and this stock or that bond or
Okay.
this piece of artwork. You don't get into that. You don't
Got it.
characterize assets.
Got it.
It's like a pot, and it all falls in the pot, and it's
Got it.
up to the executors or estate trustees to figure this out.
Got it. I mean, that being said, the owner of the assets, they have the option of creating a separate document and listing all that to make life easier for.
Yeah, yeah. And in fact, one of the things I do, it never goes in a will, but one of the practical off to the side things I tell clients is make up an asset liability sheet.
Yeah.
Make up a balance sheet. What I have and what I owe, spelled O-W-E. What are my
Yeah.
assets and what are my liabilities? And write it out, because in most families, it's going to be one or the other of ma and pa who look after this. Very seldom is it both ma and pa doing this, right?
Right.
Like in my particular case, my wife loves doing this stuff. I don't want to be involved in it. She knows more about it than I do, all right? So she has all these lists, but I know where they are. If something happened, I know where in one of our bedrooms to look for all of our papers. They're all nicely put together, right?
Got it.
But that's very valuable to clip together with the will, so that whoever the estate trustees will say, okay, mom died, dad died, here's what they want done with the assets. They want the liabilities paid off. Oh yeah, they wrote me out a nice sheet. When I say wrote, everybody's using computers now pretty well.
Yeah.
They typed or computerized, whatever language you want to use, a list of all the assets with specifics, so you know exactly what they are, not generalities, specifics, and the same story for the debts. And that means that they can hit the road running doing administration. Otherwise, they're gonna throw their hands up saying, I don't know what mom and dad did. I don't know what they own. I don't know what they owe. They never told me anything. You gotta write it out.
But you're not obligated to write that in the actual will.
Not in the will, just a little piece of
Got it.
paper off to the side, keep it together.
And I've seen some, there are even estate directories, which is this document where you can essentially write, you can get those documents online. I can even, I may
You
be
don't
able
even need
to.
to, you just make up something. I mean, it's common sense. Here's what I have, here are my debts. That's two columns, an A and a B column. You don't have to go online for that. You just think it out.
For sure,
It's
makes
very
sense.
simple to do.
Yeah, let's not get too complicated.
Yeah, one of the reasons for not listing a lot of assets, okay, in a will is you may get rid of your stuff during your lifetime, and by the time you die, you don't have it anymore.
Yeah.
You don't want to sort of do too much. You just want to do what you have to and let the trustees figure it out.
Got it.
That's what their job is.
Got it.
Now,
so we
flipped ahead a little bit. So let me see.
Is there, so I mean, we talked about the different parties involved, the share, the ownership they live to the beneficiaries and the cities in which they reside. Now, Jack, I wanted to ask you something, because I've seen some, and maybe this would go into the category of things not to do, okay? When speaking about the estate trustee, you mentioned how you would have, one person and then have a backup or an alternative. Now, I remember meeting a lady at a networking event, and she was telling me that she was now dealing with her mother's estate, and her mother, unbeknownst to her, had listed 3 people as the executor, like literally 3 people.
That's fine.
Okay, but they were not as a backup, but 3 people were the executor, like co-executors. And one of the ladies that had been listed was blind and had Alzheimer's, and like in other words, this was a bad situation, because this person was no longer even capable. So
it's okay. All right, I didn't mention this so far. If you're doing more than one estate trustee, it's safer to stay with odd numbers, not even.
Okay, so
odd number is 3, 1 or 3, right?
Okay.
And even number is 2. Why are even numbers bad? If there's a fight, how do you get a decision made?
Yeah, then you need to get somebody like yourself, like an arbitrator or a mediator.
Well, yeah, or you go to court and knock one off. I mean, you're into litigation when that happens.
Mucho dinero. Don't do it, guys. Okay.
That's right. It's going to cost a lot of money. But 3 is okay. But remember, I said at the very beginning, I had one client every year. I think it was October. Should I come in and redo my will? And I said, is there a change? And she said, no. I said, so then why waste time and money doing it? One of the changes in your situation, the situation you're telling me about, is if the lady who was blind and had Alzheimer's was known to be blind and have Alzheimer's, whoever made the will should have gotten into a lawyer's office saying, I got to knock that person off. Either just leave it at 2 or add a new 3rd one and redo the will.
Got it.
The fault in that case, I'm not trying to blame anybody, lies with the person making the will. You got to watch out. You got
For
to
sure.
have your eyes open, watch what you're doing.
Like, I don't know when the will had been set up. It probably had been a
Yeah.
while, but then bottom line,
They probably didn't follow up, and then all of a sudden there's a mess.
yeah.
The
So
simple
the
answer
other,
is, if a person has Alzheimer's, they can't resign. You know, you can resign an executorship or an estate trusteeship, but if you have Alzheimer's, you can't do anything. There'd have
right.
to be a court order removing that person. There's a statute for that, but it's going to cost money.
Wow.
The
Got
way it
it.
goes. What it means is
Interesting.
the lawyers will make some money and the beneficiaries will get less. That's the bottom line.
Got it. Got it.
Yeah, it's
And the
unfortunate,
other,
but
no,
because they
thanks.
didn't look after things when they could have.
So in other words, the person making the will, who I believe is called a testator.
That's right.
Yeah.
Yeah.
That person should have kind of known what was going on and updated.
You know what? When you get in the car and you drive, right? You can't have a blindfold on, or you're going to hit something, right? The same thing with wills. The
Okay.
same thing with life. It sort of helps if you're watching, your eyes are in front of you. You got to watch what you're doing.
Fair
If
enough.
you see a change that dictates the need for change in the will, get to the lawyer and make it.
Got it. So
there's no way around it.
Thank you, Jack. And I know we're going to be covering a few other areas, but since we're on the topic of estate trustees, also known as executors, I've come across cases where the person tells me, you know, and I remember this was a lady who was already of a certain age and she hadn't yet made a will. And part of her excuse, if we could call it, was that she didn't know she actually didn't have any heirs apparent. And she was single, no children. I believe she had been married before, but bottom line, she didn't know who to name as the executor. So I found out, being in the life insurance business and going to trusts and estates type conferences, that there are firms out there that will actually perform executor duties.
Yeah.
Do you have anything to say to that? Because somebody could say, listen, I don't have anybody that comes to mind.
She didn't have anybody.
This lady says she didn't have anybody, you know.
Wow.
Or I guess anybody that she trusted, you know, because you think, you know, a good friend.
Yeah.
But I mean, you know, I'm thinking, in my case, you know, I chose to name my brother. I could have named my mother, but I thought to myself, okay.
Well, let's deal with her situation first.
Sure, yeah.
Was this a big estate? Was it a large estate? The assets, was it a big number?
It sounds to me that she had I met her at an event that talked about, you know, charitable giving and essentially living a legacy.
How big was her estate? How much
I
money?
didn't know her that well. I mean, this was just in a social setting, and she asked a question because there was a session talking about estate planning and making charitable donations and things like that.
Yeah, it's hard to answer without facts. Like, lawyers work with facts. We don't have facts, we can't really say anything.
Okay.
What I can tell you is that just about every big bank has an estate division connected with it.
Okay.
Bank of Montreal has an estate section to it, and they're also Nesbitt Burns, which is the stockbroking end of it. Okay. Toronto Dominion Bank many years ago took over Canada Trust. That's their estate division. Bank of Nova Scotia years ago took over National Trust. So just about all of the banks have an estate division. Yeah. They will do this kind of work, and it's a contract. She's got to negotiate it. She'd have to sort of make contact with them. I can't deal with this today. Yeah. And it works in percentages. The bigger the estate, the smaller the percentage. The smaller the estate, the higher the percentage. Okay, but they're actually very fair, because I did some of that work, not recently, but a number of years ago, for clients of Scotia and clients of TD. And I saw their contracts, and they were very, very fair. Okay, they're not taking the blood out of anybody, not by any means.
Yeah, and speaking of that, Jack, I remember when I did my will, I believe there's some reasonable compensation that is allowed for executors.
Yeah.
And
correct.
Do you care to comment on that? Because I'm not sure what.
Yeah, no problem.
Is there a percentage that's kind of common?
For I'm not talking about sort of the TDs and the BMOs and all the rest of it. That's a little different, right?
No.
But for the average person, right, just an individual, not a.
Yeah, I'm leaving. Let's say my brother. He deserves to get compensated for all the work of running around, closing my bank account, whatever it is that he had to do. You know. The
compensation is provided by law, and it's up to 5%.
Okay.
Of assets and 5% of liabilities. What they do is they split it between I don't want to make it too complicated because
Sure.
I could be 4 hours doing this, but
No.
it's between assets and liabilities to make it simple for people, up to 5%. That's
Okay.
that's the chop off is 5%.
Got it.
It gets much more complex. When that happens, there are court proceedings for what's called passing accounts. In other words, that the executor would have to go, the estate trustee executor would have to go to court and have all kinds of documents, have a CA firm create a binder that's probably 2 inches thick if it's a sophisticated case, and have a judge look at the numbers and say, yeah, okay.
In other words,
So
you
it's
deserve
on
to
a
get paid
judge's
more
approval.
because this is so complex and so time
Yeah.
consuming.
Yeah.
Okay.
But
Makes
the
sense.
simple answer is up to 5% without
Up
getting
to.
too complicated.
Now, do you have that? Does that get specified in the will when you draft the will? Is it recommended that you specify that percentage, or do you leave
You
it
don't
as?
have to because the law provides for it.
Okay, interesting.
No.
Okay,
Yeah.
good to know. Thank you for sharing that.
Yeah.
So I think the next slide has to do with what
Yeah.
we were talking about earlier, which is minors.
Yeah, well, you mentioned your kids, and so if you have, when you make your will,
Mhm.
you're reading the will at the date you make it. Not obviously when you die, you're not going to know when that is. So if you're making
Yeah.
a will and you have kids who are underage, then you don't have to, but you should name at least one guardian. And if you have now again, you don't want a guardian to be your parents. I mean, if you don't have anybody else, it may have to be, right? But
Yeah.
you prefer to have somebody who's younger than you, not older than you.
Yeah.
Like a sister, a brother.
Or a good
If you
friend.
don't have a sister or brother, if you have a really, really close friend who is also a friend to the kid,
Yeah.
that could work. You have to figure this out. This takes a little bit of work.
Yeah, I remember. I mean, in my case, I did end up naming my mother,
Yeah.
at least for the time being. If God
Right.
forbid, we'll see how things go. Obviously, she
Right.
has to be capable and so on. And I think I named my mom and my dad, or I named my mom and then, but she's married to my dad. I forgot how that worked.
Yeah.
But
Well,
it's,
usually name both. Often it's both. My mother, Maria, my father, Jose,
yeah,
whatever.
I
his name
believe I
is.
did. I believe I did name them
Yeah.
both because
You can
they,
do that.
they're married.
So
Yeah.
that's something that should be revised, every so often. Because
Yeah.
let's say your parents are starting to get sick, and
No,
you're
for
in
sure.
touch with them, and they say, you know what, God forbid if something happens to you,
Yeah.
we can't do this anymore. You're
Yeah.
going to have to cast for somebody younger. So
For sure.
it's like my example, when you drive, you don't drive with a blindfold. You got to watch in front of you what's
Yeah.
going on.
Yeah. Yeah.
And if you
Now,
have
let
to
me ask
change
you,
something, you change it.
I have a logical question, like as a follow-up to that. Like in my
Yeah, that's
case,
fine. Yeah.
in my case, my child's father was not in the picture and he's not on the birth certificate, and like there's nothing like that going on. But in most other cases, even for single parents, you're gonna have
Right.
parents that are separated, maybe co-parenting.
Could be, yeah.
Now, if myself as a mother, I'm doing the will, is there some sort of a legal provision that grants automatic guardianship to the other parent? Because this is a question a lot of single and co-parenting parents may want to know.
No,
So if
you have to say what you want. Like, it's your choice.
Okay.
You have to say something in the will. I appoint so-and-so as the guardian of my child during his minority, having confidence in his or her ability to do so. There's a clause for that. You got to pick who you have.
So I can choose, so even if I'm co-parenting with the other parent, let's say they have some sort of a co-parenting agreement,
right?
When it comes to my parenting duties, I could still name my mother or my good friend or whoever it is to take over my parenting duties while the other parent maintains theirs.
Yeah, and that's fine. I mean,
Okay.
if there's separation or divorce situation and you've got the children 4 days a week and your ex-spouse has the children 3 days a week, that doesn't mean that, he's cut out.
Right. That doesn't mean that he's cut out.
He have to do his thing and you do your thing,
Yeah. No, but in the case, and again, maybe we're going to discuss that when it comes to, this is another example of why a will is necessary, because in this sort of situation, if somebody passed away without a will, the co-parent may now be seen as the next of kin for that child.
They could come forward and say, look, I know that my ex-wife, who now is my late ex-wife, never made provision for this. I know that. We talked, whoever talks.
Yeah.
And I'd like to propose that I be the guardian. It's really important to put something in. It blocks that kind of stuff out.
That's right, because otherwise, and for example, let's say a grandparent was involved, now it could be a battle between the other parent and the grandparent for guardianship. And this is what you want to avoid by drafting a will.
Yeah,
This
you
is
got to do something. Like doing
prime
nothing is
example.
really not a good practice, all right?
Got it.
I mean, if you
No,
don't have kids, you don't have to worry. But if you do have kids, they're over 18, it's not an issue. But if they're anywhere from, they just got born to the age of 18, you've got to think about this.
absolutely.
Okay.
And of course that's what I had to do,
Yeah.
and I sleep better knowing that that's in place.
Yeah.
Now maybe we'll talk about people who don't have any kids, but they may have some assets, or maybe they don't have anything at all. We're going to talk about what happens if you don't have any will.
Yeah, just if we can go back, because you flipped over the last one, I wasn't quite done yet.
Yeah,
Okay.
what is this all about? Sorry.
Yeah, trust provision. Children who are under 18 by law are not of age. They can't get hold of property. So if I made a will up for somebody and they tell me I've got a 3-year-old, a 5-year-old, and a 9-year-old, I'm going to create a provision that ultimately on the death of the client, right, the testator, that any property that is to go to those children can only go to them as each one attains the age of 18. It's a trust provision. Because they're not entitled. You can't give a minor property. You just can't.
That's interesting, because I hear people all the time, oh, I bought that property for my son, but it's in trust.
In trust, but they can't give it to them yet. So when they're 18, they can.
Okay.
But so from 0 and something to 18, there's got to be a trust. After that, no problem.
Got it. And when you say there's got to be a trust, that the construct of the trust gets created through the writing of the will, and in this case through the
we do it
passing
automatically. There's a provision in there. It's automatic.
I remember, because in my case, I actually had to even specify that I want a certain percentage to go to him when he's 18, a certain percentage when he's 25, and so on. Because you may not want to have millions of dollars worth of assets, not that I have that, but for somebody who may have that, they may not want to leave everything to an 18-year-old right away.
Most people don't, to be honest with you. The average 18-year-old is...
I was a hippie at 18.
What? If it were up to me, if I were running the government, which I'm not interested in doing, they can have it, all right? I think the age majority would be 35. Because, what, and boys mature more slowly than girls. Girls are better at it, all right? But boys, men are much worse at it. There's a point where when you're in your 20s, even your late 20s, where there's a silliness. And when it comes to handling money, if you haven't been trained what to do with money, and most people are not, they don't know anything about money.
No, I know.
Boy, can they ever blow it.
No, and I actually
First thing is, I'm going to get myself, let's say it's a $5 million estate. A day later, I'm going to go buy a $400,000 Maserati.
Yeah.
You could have got yourself a Lexus for maybe $50,000. It's a nice car too.
Sure.
But you got a lot of stupid behavior. At the lower end edges of age range where people really are not competent. All right, 18 is very young, but the geniuses who set up our legal system are the geniuses who run us, and that's what it is. So.
And this is yet another reason why you want to set up a will, because then you get to decide how much of your assets would go to your child in this case, and at what age. And you don't necessarily want to, and even if we're not talking about a very large amount, but to an 18-year-old, even like $50,000 is like, oh, I can just party. And unfortunately, I've had a personal experience with somebody in my life who at a young age inherited, and this person unfortunately was not super responsible. And
most people are not. They just, you have to know something to be responsible. So
live and learn. So very interesting. What is this add a provision excluding any son-in-law, daughter-in-law?
I thought you were going there. Here, you looked down for a second, so I thought you were going there.
Sorry. What is this all about?
You want to make sure if mom and pa die and they got kids, that anything that is going to a son or a daughter, not an in-law son or an in-law daughter. There's a clause that's about, I don't know, 8 or 9 lines long. I put this in all my wills. It's also
this is huge.
Pull it off and there it goes. It just means you're trying to follow your descent line and you're not going out to in-laws.
Wow.
And the reason for that, the family law. We have an act called the Family Law Act. And it's extra support for, there's a section of our Family Law Act, Section 5, that tells you when in-law children don't share, okay? So this is sort of extra support for that. You want to make sure that it doesn't go where you don't want it to go.
Right, because especially if there's a later case of a divorce, that's where all of a sudden, so there is a provision, is that part of this law of wills?
In my wills, I automatically have a clause that is 7 or 8. obviously for the purposes of today, I'm not giving a law lecture, right?
No.
This is
Yeah.
just, so I put a provision in that covers what I've just put in my charts.
This is really important, and I'm glad you brought it up, Jack, because I actually remember speaking to a lady, and she had specifically that concern. Like, she only had one son. Now, this lady had done pretty well for herself. She had multiple properties, and she was, worried about, the daughter-in-law who it was a recent relationship.
I know where you're going.
Yeah. So
the daughter-in-law is a gold digger. Can she dig for gold
we
in her?
don't know. I mean, bottom line, the mother was not feeling super confident about the relationship.
I understand. Yeah.
So she was concerned. So, but you're saying that very well through the will, that person. So if right now the son is married to this woman, but later they were to get divorced, the property that came from the mother would remain in the son's name, as long as that was properly drafted. If that is not in the will, could then the spouse lay claim to those assets?
Well, okay, the section of the Family Law Act, it gets complicated. I don't want to get sidetracked.
Okay, sorry.
We could be here about 7 hours doing this.
I know. We're trying to keep it to about an hour. Oh my, okay.
But the Family Law Act has a provision that says that one of the things that's not shared by, we'll call it a son or a daughter to make it easier for everybody, is anything that comes from an estate to that son or that daughter, not shared with the son's wife or the daughter's husband.
Okay.
There's already provision for that.
Okay.
What this does, this is like adding extra cement to it.
Okay.
You're saying it twice.
Got it.
I don't want to get too complicated, but
got it.
it's a good thing to have.
I remember, because I have clients who have inherited money from a grandparent in this case, and then that was clearly in a separate account, and it was not commingled with the marital assets.
I understand. Yep.
Got it. Okay, so that's good to know, so people can have peace of mind to know that.
It's not complicated, and when I review a will, I say the reason for this is, and okay, fine, and that's it.
Yeah, extra clarity.
Okay.
Yeah.
Now we're getting to the formalities of a will.
Yeah.
That come from the Succession Law Reform Act.
Okay.
That if you're doing what we call a lawyer's will, a formal will, the lawyer has to see the testator, and there have to be 2 witnesses standing by. And the witnesses can't be a beneficiary, and they can't be an estate trustee, someone else.
Okay.
Usually, if they're done in a lawyer's office and you have staff around, you use a staff member.
Yeah.
Assistant number 1, assistant number 2, and you don't get into this nonsense with other people, right? But it's got to be signature and 2 witnesses. Right?
Got it.
And it's all done so that the witnesses print in their names so you can read them afterward in case they scribble in a way where you don't know what they're scribbling. So it's got to be done legibly.
Okay.
And the witnesses also have to be at least 18 years old.
Okay.
Can't have kids involved in this stuff. And I already mentioned a witness can't be a trustee or a beneficiary.
Yeah.
And then, although it's not required, but a lot of lawyers get very jumpy about forgery. So I was always taught that, let's say your typical Ma and Pa will is 3 to 4 pages. That's what it is.
Mm-hmm.
You're not talking about the president of General Motors who has a will, 75 pages, right? Most people, if it's an average couple, average will, 3 to 4 pages. We get 3 sets of initials on the first page and on the second. Let's say the third page is the signature page. No need to initial there because you're signing anyway.
Right.
Okay.
Got it.
Now, it's not a requirement, and I've seen wills, fly around where nobody initialed. The problem is if it looks like a page was fiddled with, like somebody went back and started doctoring something. The courts examine these and they'll say, "Ooh, it looks like somebody fiddled with this, and I'm not seeing an initial." So a judge will know that the person made that initial, right?
Got it.
It's safer to initial. That's what I'm saying.
Got it, Jack. Thanks for clarifying that.
Chance, right?
Now, you and I were speaking prior to today's call about, the new reality that we find ourselves in with online, a lot of online appointments, and then people not necessarily coming in person. So you mentioned that there is the possibility of either doing it through a Zoom meeting whereby the Zoom meeting is recorded, you see the 2 witnesses coming to sign. And in addition to that, you recommend that.
The only other way I can see of doing it is serial photography, not Zoom, because Zoom is basically television, right? I call it TV, but would be serial photographs that are taken in a sequence showing the person signing. They sign from the left to the right,
Okay.
And the photographs are emailed and they can be printed, and the lawyer keeps it in the pouch, in the package and whatnot. It's a
Okay.
possibility.
Okay.
It's going to be a short-term thing. I think at some point, I suspect what will happen is lawyers are starting to reopen their offices.
Mm-hmm.
We can't be hiding in our bathrooms for the next 4 years. We're going to crack up. It's not going to work. At some point, people take chances, right?
Of
They'll
course.
come into a lawyer's office, and typically what we're being told by the Law Society, if you're reopening your office, because they've already done this stuff with us,
Sure.
what
Yeah.
safety procedures?
Okay.
Number one, check with your client that they're not coughing all over the place. I mean, this is
Okay.
common sense. You don't need a medical degree to figure this out, right?
Yeah.
Most lawyers are not going to be equipped with a temperature machine. You can buy these to take somebody's temperature, but I'm not a nurse and I'm not a doctor.
Oh, yeah. At the end of the day,
You
that's
know,
not your job.
there's other people who deal
That's
with
right.
it.
It's not
But
your
you
job to do
screen
that.
them in advance and you talk to them on the phone. Is everybody okay? Has anybody had COVID? Are
Yeah.
you fine now? Do you have any cough or anything that
Sure.
suggests that they could be symptomatic with COVID-19?
Yeah.
And if you speak to your client enough over you get a sense of people. You know, if they're hacking all over the place, don't come to my office. I wouldn't want them anyway if somebody's sick. I don't need to catch
Got
somebody else's stuff, right?
So that actually brings me, got it. Sorry, go ahead,
Most
Jack.
lawyers will have a boardroom,
Yep.
and the boardroom will have a table.
Yep.
And you seat them far enough away, right? And your witnesses so that you're at least 6 feet away.
Yeah.
A lot of boardrooms have 12 and 18 feet.
Oh, yeah.
Next
Yeah.
to them. And, you know, and you could insist that they mask themselves when they come in, and you do the same. So, you
Sure.
know, the fact you have a mask on doesn't mean you can't hold a pen in your hand.
Right,
It
of
has
course.
nothing to do
Of
with
course.
another.
Yeah.
It really, as long as people use common sense and they're cautious, then they're knocking out the risk, right? Especially
now,
if you keep
Jack,
away from one another, right?
With that said, so I understand that the in-person signing will soon be an option again. I know
It'll come
you
back.
have access to an office space and all that. But the
That's-
question, but if the person says to you, you know what, but I just want to do everything online, can we do it this other way? You can accommodate them as long as they're willing to
it can be
cooperate.
done.
And
Yeah, it'll cost a little more because we've got more headache to worry about doing it online. It's not,
Okay.
you know, it's not like watching Walt Disney show and whatnot. It's more work for us.
it's a legal process and it has to be done
There's a
properly.
cost to doing it that way.
No
It's
worries.
easier and less fussy to use the old-fashioned technology was come in.
Yeah.
I mean, ordinarily when a client would come in, if I know who they are, I've acted for them before, I'm going to recognize them. Okay, I look at their face, so I know who they are.
Yeah, for
If
sure.
I haven't acted for them before, and especially if it's an online kind of thing, I'll probably ask for 2 photo ID things from them.
Okay, that makes sense.
Drivers and health, because I don't know who they are. How do I know who the person sitting on a Zoom conference is? I've never met them before.
Fair enough.
So at least if I see somebody on Zoom,
Yeah.
you know, like you're looking at me, I'm looking at you, and I look at, I'll say, okay, that's Letitia. I know what she looks like. We've talked before, we've met before, whatever.
Got it.
So we've got, you know, extra layers that we have to add in just to be sure that that's the person I think I'm dealing with.
That makes sense. That makes sense.
As opposed to a fraud artist or something.
So I guess my other question, Jack, would be, because I know some of our audience lives in different parts of Canada.
Right.
You're a lawyer licensed. Now, how does it work for a lawyer?
Ontario.
Ontario. So just like for us in the insurance business. So if I have somebody from BC watching and wanting to work with you, you'd have to refer them to one of your colleagues.
They'd have to find a local lawyer in BC.
Got it. Yeah, and you might have, I don't know if you have any colleagues across the country that you feel comfortable referring. I'm just giving you the example.
In a few places, but my work is pretty well in the GTA. I mean, that's where I work, is the GTA.
Yeah, that's okay. But ultimately you're licensed for Ontario. So even if they live in small town Ontario, either they're willing to come in person but ultimately,
or we do the electronic stuff. Yeah.
Absolutely. And something to keep in mind is that most of the process can be done online in terms of like you providing the information. They can provide ahead of time the information that's needed. And it's just for that final signing that these formalities are needed.
I tend to talk to people. I'm old fashioned because I've been at this for 44 years. You know, I wasn't born with a computer in my ear or something. All right.
You're doing it.
My generation learned on typewriters, and then computers came later. A lot of us that are older love the telephone.
Yeah, that's totally
Greatest
fine.
invention is the telephone. It almost never fails. Computers, not so much.
Yeah,
so
I know.
What winds up
told me
happening with the phone, you just get on the phone, you talk to people, and you get information. The other thing is, because not everybody, but a lot of people are computerized and they have email. We could always say, look, would you email me the following fact information? Fact. They
Yeah.
send it to me,
Yeah.
and then I go to my computer. I do my own thing.
Yeah.
And then, I can send them a draft copy of it. You want to change something because it's all in and out, right?
Yeah.
And then the signing. So
Yeah.
the only time that we have some kind of meeting is the signing. The other stuff can be on the phone or emails.
Yeah, I got it. Okay, Jack, I just want to be aware, somewhat conscious of the time because we're already at 5 p.m. and I don't want to, normally I want to save within an hour and
No
15
problem.
minutes if we could.
Yep.
And we already spoke about the wills. Like we didn't talk about, well, this is the big question. What
Okay,
happens? Somebody, yeah.
Here's what I told Letitia this one. So this is what happens if you die without a will, and in bigger print, the results will likely disappoint. I'm
Yeah.
going to tell you a story. Okay?
Sure.
A client of mine, it was a husband and wife. I'd acted for them on different things. Calls me up, and she mentions to me that their home, they didn't have a cottage, they had a house, right? Fully paid. And the home was registered in the husband's name alone. Most couples, joint tenants.
Yeah.
He dies, she gets. She dies, he gets. They didn't do it that way. I don't know why. They didn't think about it. She was aware that there was something called joint tenancy, which is that you have two names on the deed. One dies, the name gets removed, and the other one is there. But without a joint tenancy, two names on the deed, he's alone. If he dies, the property goes into his estate with all the other assets.
Wow.
Okay. I don't know if they knew it or not. Anyway, when she called me, I said, get in right away because I'm going to do two things for you. I'm going to shift the deed to joint tenancy, you and your husband, so you don't have any of this nonsense with he's the only owner. Right? And number two, we'll do some quick wills. 3-4 page wills, in and out, no problem. I didn't hear back from her. She calls me maybe 2 months, 3 months later. She's crying her eyes out. I asked her, what was going on. Her husband went on a fishing trip. He was the outdoors type.
Oh,
I
my
think
goodness.
they were in their early 50s at the time. I was probably in my 40s then, right?
Wow.
And he went on a fishing trip, and it was too much for him. He had a fatal heart attack.
Oh my God. Right? Wow. So totally unexpected, Jack. It wasn't like the man was.
Nobody knew. She calls me up and she says, here are the facts, all right? The property, as you know, is in my husband's name. Okay. It's going to drop into his estate where the assets and the liabilities go. We talked about that before. Number two, I have two grown kids. I have a daughter, I have a son. The daughter and the son had already gotten legal counsel, so they knew what I'm about to tell everybody. Okay. Under the Succession Law Reform Act, which I've referred to second to last line on the slide, that basically says if you don't make a will, where does the property go once the bills are paid off? So what it says is if you're a legal spouse, there's a marriage there, not common law, legal spouse.
Legal spouse, marriage.
And one dies and the other one's still around. The one who survives, in this case the wife, gets $250,000 off the top. Assuming there is 250,000.
Yeah.
The first 250 goes to her. It's called a preferential share. After that, whatever's left over, the bills are paid off the top. You count noses. So you got a surviving wife, a daughter, and a son. So a third, and a third. Which means that the son and the daughter would get access to their 1/3 share of all of the assets immediately. Had the husband and wife done
the
wills,
first third in this case would go to the wife, Jack, just to
third to the wife, third to the son, a third to the daughter.
Got it. Okay.
Had they made wills, I wouldn't have made wills like that. I would have made sure that everything he's got goes to her and everything she's got goes to him and then the kids.
Yeah.
Okay.
Yeah.
So what happened was the daughter was a real sweetheart. She already knew what the law was. She checked with the lawyer and said, Mom, you're going to need your money. I'll wait. Okay. I don't want to take it out of your pocket.
Yeah.
The son was a son of a bitch, right? Sorry for the language, but that's what he was. Not my language, her language.
Wow.
And I said, wow. I said, he had no, and I don't think she worked.
Wow.
And at the age of 50, where is she going to just, no job skills, where is she going to land a job?
Wow.
He had absolutely no compassion for his mom whatsoever. I was disgusted.
Wow.
I said, you know what? I feel terribly for you. Unfortunately, my hands are tied. I can't do anything. The Succession Law Reform Act says if you die without a will, there's a chart. It goes, it goes, it goes, it goes, it goes. And I said, you're out of luck. I couldn't do a damn thing for me.
So in other words, the house had to be sold so that the son could get his share.
The son his share, yeah.
And there was no way.
Her 1/3 share. Daughter released her 1/3 share and said to Mom, here, I don't want anything. Okay, I'll wait till later. The son wanted a third of whatever was there after the debts were paid off. I don't think I ever heard back from her after it. I don't know what happened. She was a
Yeah,
basket.
no.
So if you're legally married and you think you can, die if you don't have anything, who cares? But if you have property, all right, and you've got kids, you don't want to die without a will.
No,
That's why I say prepare to be disappointed.
no, and now, Jack, maybe this would be a good time to bring up the idea of people living common law, because I remember talking to this gentleman, whom
Yeah.
again I met at a real estate investors event,
Yeah.
and he had a number of properties, and he was in a common law relationship,
Yeah.
had a child, minor child. They didn't have a will,
Yeah.
and the properties were obviously in his name. Like this, he had. Well, actually, I'm not even sure. They might have even bought some properties together, but bottom line, they didn't have a will. So tell people what happens, because you just explained what happens if there's a legal marriage relationship. The first 250 goes to the surviving spouse.
Right.
The remaining, let's say if there's 3 children,
Yeah.
no, if there's 2 children, then the first third goes to the surviving spouse, and then the remaining 2/3, 1/3 to each kid.
Okay, so forget all of that.
Oh,
You got a common law husband and wife.
yeah,
One of them dies, right?
Yeah.
They're common law, so they're not legally married. They're just
Yeah.
living together. None of what I just told you applies at all.
none.
And there's nothing for the common law wife.
Wow.
Zero. Because she's not a legal spouse.
Wow. So is it as
Okay.
if this person was a stranger? Like literally?
So let's say they live together for 15, 17, 20, 25 years. Zippo, nothing. Because the key is,
Listen up, everybody, in case you're in a
Yeah,
common law
well,
relationship or
and that's
no others. Yeah.
when I was looking for graphics, right? My wife, who's more techie than I am, as Letitia knows, I'm not big on tech. I put up with it. But I did all the writing and I did all the charting.
No, you guys are awesome.
She made this stuff up, okay? I mean, I did the writing, she did the tech part.
That's a
There's
will.
no way I'd ever get it done.
Yeah.
I found that little graphic, dying without a will, and then the circle with the little red mark. I said, oh, that's a good one. I like that. Because it's going to scare the pants out of anybody who listens to it. And it should.
No.
It
Wow.
should scare the pants out of them.
Wow.
So the bottom line is, his child will be protected because the child is a blood relative to the father.
Yeah.
But the wife, the common law wife of 12, 15, 17, 25 years gets Zippo.
Wow.
Because she's not a spouse.
No, let me, oh my gosh. You know what? We may have to leave the powers of attorney conversation for, I would like to cover it as well, but I mean, I'm just concerned that
if everybody can stay on, people listen, or if they got to go, they got to go.
People go in and out.
Go to it quickly. I'll go over it very fast.
I do have one follow-up question though, and a crazy story. That speaking of this whole idea of a common law spouse and a legal marriage spouse. So I heard this story from a fellow advisor of one of his clients. I think the client was the wife in this, or the common law spouse. So what had happened was this gentleman, who was a gentleman of means, he basically became, he had a will, or he had been married before, okay? And I believe he had a will with his first wife, we could say. Now, he never legally got divorced. He was separated, but got into what we would call a common law relationship with a long-term common law spouse.
I know what's coming. I know what's coming.
So get this. So the man was now of a certain age. Now, he had done very well for himself, but again, continued living in this common law relationship, never drafted another will.
Yeah.
Passes away.
Yeah.
All of a sudden, the first wife from 20 years ago shows up asking for money, and the common law spouse was completely, had nothing.
And you know what? It's amazing how sometimes people with money, I don't know whether it's just ignorance or whether they get cheap.
It's ignorance, so people don't get around to it. I think people just, number one, ignorance, they don't know what the consequences are. Number two,
or they think they're going to live forever and it's irrelevant to them.
They put it off. It's like, oh yeah, I know I got to get it done, but like,
we're all going to live forever, right? Yeah.
Oh my gosh.
Anyway, the bottom line, you already know the answer. The bottom line is, because I already told you part of it, the common law wife, 0. She's not a legal spouse. The legal wife, they're separated, but they're not divorced. Okay.
So what happens then? Like is that the
wife
same as being married?
The wife that he was separated from gets the estate because he's not divorced from her.
Wow.
If he had gotten divorced, divorce cancels any previous will.
Okay, thank you.
Remarriage cancels any previous will. It's all in the Succession Law Reform Act.
Wow.
You know, it's got a lot of stuff in it. It's quite
Ladies and gentlemen, sorry to tell you, but if you're dating somebody who's separated, keep this in mind.
Divorced,
and separated and not divorced,
problem.
You have no rights.
Red lights flashing.
Yeah. Sorry to tell you.
Yeah, but there you go.
Story for you. Okay.
The more I look at this artwork, the more I like it. The other stuff that I picked out and I gave it to my wife and she did all the stuff because I'm not into tech, was a little bit more neutral. But this one really sort of grabs you with the large print, right?
Yeah, and you know what, Jack, and in this day and age of like fluid relationships, you get a lot of these situations where people get separated, they get divorced, remarried, but you want to make sure
they separate, don't divorce, and they're common law with someone else. I mean, that's a disaster.
Now, what could this person have done? Could they have drafted a new will even though they were not legally divorced?
No, sure they could have. Yeah,
they could have.
They could have made a new will.
They could have made a new will, and that would have superseded the previous will.
Yeah, that's right.
Even though they were still legally married.
If you make a new will that cancels the old will,
okay,
even without a divorce, you expressed what you want to do.
Got it.
But if you don't make a new will and you haven't been divorced and the old will's still there, that's the will.
Yeah.
It's crazy. All, fact, one foot in front of the other. A before B, B before C.
No, and that's why, you know what, Jack, that's why I want us to have this conversation. I want people to know the consequences of not doing this type of planning and the kind of mess that can happen and unintended consequences, because nobody, I mean, I'm sure this gentleman, oh my goodness. Okay, now what do we have?
We're running late. Let's go on to the powers of attorney.
Quick. I know, I apologize. Okay, so we can spend another like maybe 10 minutes, Jack, if that's okay with you.
I can get it done faster than that.
Okay, so let's talk about the other two important documents that you hear about, which are called powers of attorney. So I'll flip to that. Go ahead, Jack. Go ahead.
Okay, there are two. One form is something called property power of attorney, which is exactly what it is. It gives a power to someone, at least one someone, it could be more than one, to look after a person's affairs while they're alive. Wills are you look after somebody's dead.
Yeah.
Powers of attorney while they're alive. So they don't overlap.
Right.
They sort of touch at a point. Like when you die, your power of attorney is garbage, and then the will takes over. Right?
But this person is alive, but cannot speak for themselves anymore for whatever.
Well, it doesn't have to be. A power of attorney, first of all, there are two types, right? There's property, which property is property, and there's healthcare. More often than not, either of those, whether it's dealing with property or whether it's dealing with health issues, it comes up when somebody is disabled and they can't look after themselves. So they get someone else, a spouse or their kids, to do the looking after, right?
Yeah.
It doesn't have to be. Here's an example. There are people, and this is very true of professors who take professorships in foreign universities in foreign countries. They go on a sabbatical year, which is 1 year, right? And they go to Australia, all right? And they leave their spouse, if there is one, or their adult kids, if there is one, with powers of attorney. Not so much for healthcare, because the kids are in Canada and dad went off to teach in Australia.
Got it.
More likely the property. If my mortgage has to be renewed, he's not going to run back from Australia to do that.
God.
So the power of attorney allows that kind of thing to be done. When dad comes back, he doesn't need them to act as attorney anymore. So all the power of attorney is, it's an agency document allowing somebody to look after another person's affairs.
Wow.
Either because they're absent, he's in Australia, or because they're sick and they just can't anymore.
That's fascinating.
So it's not just a sickness kind of thing. It can be, but it doesn't have to be.
What in the case of somebody being out of country, for example, how can we prevent fraud from happening? I mean,
it's a very good question. And you know what? I actually had a case like that. It didn't go anywhere. I don't think the party involved wanted to sort of mix it up, but it was between a child and a parent, and I'm not sure what the relationship was, but the parent became aware of what were clearly unapproved transactions.
Wow.
All right. The parent had gone away, child was here, had access to bank accounts and this, that, and the next thing. And the next thing I know, there's allegations of fraud.
Wow.
But I don't know what he did. I never approved it. I never talked to him about it. He used the power of attorney, which was copy with the bank, copy with him. It was a valid document. And the kid was a crook.
Wow.
So a power of attorney is a very dangerous weapon. And I think I mentioned at the very end, I said, it's probably the next slide. You have to trust the people you're dealing with. Okay. Yeah.
Yeah. Be extremely careful who you choose.
Be careful who you choose.
Okay.
These relationships are based on trust. If you have a kid who's sticky fingers, you better find someone else. You know?
Wow.
You have to be careful. You know, you drive with your eyes in front of you, no blindfold, right?
And
You
I
have to
mean,
know your children. If you've got kids who are spendthrifts, if you give them $5, they'll spend 15. Or if they are incompetent, you just talk to them. You say, that kid is, he's missing space up here. Okay, like he's just not together.
that would
Well,
be
it
very
happens.
unfortunate if that's
You
your
got to know
child.
your children, right?
Wow.
Or if you figure the kid's really bright, he's very strategic, but he's got a dishonest streak. It's almost like he'll strip the hell out of the
They'll
person.
screw you. Yeah.
Yeah, just
Wow.
for his own benefit. So if you have a kid who doesn't come across as really with it, or you have a kid who sort of just doesn't seem to, they're just not ready for the job. They're just not ready. Okay, it's, you have to know your kids. Or even worse, you've got a kid who's ready for the job, but he's a crook, and you see him that way, and you know that the minute he's got his clutches, he or she has his clutches on assets,
Wow.
bye-bye assets.
Wow.
You've got to know who you're picking, and
Wow.
not just kids.
Anybody.
Could
So
be
it's a
your
big,
spouse.
it's a
Let's
big
say you have
deal.
a husband and wife, and the wife has a very funny side to her where she's not dishonest, but the minute she's got any money, it's like water through your fingers. And he says, yeah, I don't want to do that. I worked my whole life for this, and she's going to put water through the fingers. I don't want to do that kind of
Speaking of
nonsense.
that, Jack,
Yeah.
no, thank you for and I do have a quick follow-up question. So we spoke about the case, of somebody passing away without a will, and the case where they're legally married,
Yep.
versus common law.
Right.
In my understanding, again, in the case of legally married spouses, there's an automatic power of attorney that goes, if the person doesn't have a power of attorney drafted, an automatic power of attorney goes to the spouse.
There's no automatic. No, there's no automatic. You have to do one. Gotta leave
Oh,
one.
really? So
Yeah,
even
automatic is out.
okay, so even in the case of married, legally married spouses, there's no automatic.
No, I'll give you another story. All right. It's
Wow.
a good thing that I was their lawyer, because I was always very cautious. I sold, I think I told you about a year and a half ago, I sold the real estate part of my practice, which was very large, right? I had a real estate client. I bought a house for them. Right?
Sure.
I get a call from the agent, the real estate agent who referred them. And he says, Jack, do you remember Mr. and Mrs. So-and-so? I said, yeah, it was about a year ago.
Mm-hmm.
He had a major stroke. He's in the hospital.
Wow.
He's paralyzed, right side all the way down. So right arm, and right leg. Okay.
Yeah.
And they didn't do powers of attorney. They had wills, but they didn't do powers of attorney. And he cannot now give instructions to the doctor. His speech was affected on one side as well.
Yeah. Wow.
So he didn't have the property power of attorney, didn't have the healthcare power.
Wow.
I said, okay. He says, this is his question to me. This is about 5 years ago. He said, what's it going to cost to get a court order for guardianship? There's an act called the Substitute Decisions Act. It was a law that Bob Rae, his government, way back when, 1990, 1995 passed, I guess.
Okay.
And in it, it deals with court orders where there's no power of attorney. You can get the court to make an order.
Okay.
So it's a court order power of attorney as opposed to something in writing, right?
Yeah.
I said, if you had any idea what the bureaucracy was, you wouldn't ask me the question, but I'm going to tell you what the answer is. I have to do something called an application. It's a court application.
Yeah.
Supported by an affidavit sworn by the wife, because husband and wife sitting with the facts are. You would have to hire a CA to do a plan, an actual asset investment plan, and go through all their assets and all their liabilities, and accountants do this stuff. It's not lawyers.
Yeah.
And then probably 2 opinions from doctors as to how serious his disability is. So 2 medical opinions, and doctors don't like doing reports. They're busy doing what doctors do.
It can take a while. I know.
They hate doing this stuff for lawyers. Like, we're a pain in the neck for them. They don't like it.
No, I mean, even I know that.
A CA analysis and report, 2 medical reports, and a court application. And the court, forget about COVID. This was 5 years ago, maybe 10 years ago. The courts are always backed up. So you don't get in because you snap your fingers and do this. You got to wait your turn.
Wow.
I said you could be looking conservatively at maybe $6,000 or $7,000 in fees. Not just me, but the accountant wants to be paid, and the doctors want to be paid, and the court has fees, and I have fees. And God knows what time, probably months before it can be done.
Wow.
More so the accountant doing what he has to, the doctor's doing, and the court. So
no.
I'm sure 3 to 4 months easy, and a good $6 or $7 grand. He said, oh my God. And I know this was a working guy. He worked on the line. He was an operator of some sort.
Wow.
They didn't have money for this kind of stuff.
Wow.
I said, okay, you asked me a question, I answered it. Let me ask you a question. He says, go ahead. Nine people out of 10 in the world are right-handed. Okay. I'm right-handed. It looks like left because I'm facing the camera. I'm a righty. Okay. 9 out of 10 are right-handed. 1 out of 10 are what they call southpaws, lefties. All right. I said 9 out of 10 says that Mr. Senior, or whatever his name is a right-handed person. Am I right or wrong? He said, no, you're right. Because there's 9 in 10 odds he's going to be right-handed. Those are the numbers. I said, okay. Is his mind okay? Yeah. Is his left side okay? Meaning his left hand. He says, oh yeah. I said, okay. Get him some paper, get him a pen, get him to practice signing his name for the next couple of days.
Wow.
Now, if you're right-handed, you're going to have a hell of a time signing your name with the left hand because you don't have the hand skills for it.
For sure.
So it takes practice. But I said, if he keeps it up, maybe it'll take him a week just to get used to, so it's not so bad. Okay?
Oh my
I
God.
said, if you come in with $100, one power of attorney 50, the other power of attorney 50, I'll make a whole bunch of copies, give me cash, whatever. Take it to him, have 2 of the nurses that are in the hospital. I mean, I'm not going to go see him, right?
Yeah.
Have 2 of the nurses act as the witnesses, just like a will, 2 witnesses.
Wow.
Okay, and then circulate whatever you have to.
Wow.
2 years later, they couldn't stop thanking me.
Wow.
Well,
what
because
a story.
if I wanted to be a lawyer sort of doing this, you know, I could have said, okay, give me $7,000. I'll put it in my trust account. I'll arrange for 2 doctors. I'll arrange for an accountant. I'll do what I have to, and I'll get your court order. Because that was his question.
Yeah.
I didn't want to do that because I knew that, you know, like he wasn't a rich guy and I wouldn't do it anyway. The simple answer was common sense. If you're paralyzed on the right side and you're okay on the left side, who's to say you can't sign with your left hand?
Yeah, nobody.
You just need to practice. So I thought that one out. It took like a second to figure that one out because it's common sense. You don't learn this at university.
No, I know.
And I said, I got the answer for you. You don't need law for that. You just need common sense.
Wow.
A little practice.
What a story, Jack.
About 3 years later, the wife called me back. She says, you did me a really good deed. I said, well, we should be doing that kind of stuff. I said, I knew the circumstances. You're not rich people. We're writing a check for $7,000 as popcorn money or anything.
Yeah.
And that was it.
No, thank you for sharing that. But that being said, this is very poignant because what if the man had gotten into some sort of serious accident that would have affected his mental abilities as well?
Then we would have had to go to court. Then
So again, you're telling me that $100 would avoid that kind of of an expense and the potential, because now my understanding, Jack, and again, I know we got to wrap it up, is that the courts, like that if somebody doesn't have a named power of attorney, like hospitals,
the court will make an order appointing them, but it's a court order. It's not a power of attorney. It's a guardianship order.
Right.
The court has the power to do that, but you got to spend time and money to put it together.
And what happens in a hospital setting? Because what if there's no, but if somebody can show to the doctor, look, I'm the son or I'm the daughter.
Yeah, but they'll work that out. That's just practical stuff. I'm not worried about that.
Right. But again, so in terms of medical decisions, but I guess that the more serious one is if there's one of those cases where do we resuscitate, do we not resuscitate?
You can put that in the healthcare power of attorney.
That's right.
It's a standard form. Each power of attorney, whether it's property or it's healthcare, it's about 4 pages. The province has mandated the form. I don't make up my own form. It's a provincially mandated form. And one of the provisions is any conditions or restrictions. And I've had people say, in the event that I cannot be resuscitated, I do not wish to live on machines. I'm using simple language, all right?
Sure, yeah.
And I'm authorizing my attorney to basically sort of shut it all down. I'm just using simple language.
Yeah.
So we can put that in as well. Not everybody asks for it. Some people actually want it right in there, and there's a spot where we write something in.
Okay. But I mean, if in the absence of having this named power of attorney, then the hospital is kind of left up in the air. They don't know what to do.
Exactly.
And that's where a court application needs to be made at an investment of time and money to actually get the right to speak on behalf of this person.
Yeah.
So
the bottom line is this. If people are thinking and they're planning ahead, they're not just sort of, going, would you rather spend $100 and avoid a problem or spend $7,000 and deal with the problem? That's it.
No. So that brings us, and you know what, Jack, we didn't have time to talk about the whole idea of the probate process. But you know what, let's not get into that right now.
Yeah.
I know you said to me you're gonna join us for a more advanced session later and talk about some of the legal implications with corporations and
Correct.
successions.
Correct.
So we're gonna have a more advanced session talking about some of the stuff to watch out for when if you're the owner of a corporation and if you have partners.
Right.
We're gonna have a whole
We'll deal
session
with
about
that. Yeah.
corporate planning.
I didn't want to try to do too much in one day, as it is.
No, and I wanted us,
thoughts.
and we're already at almost an hour and a half, Jack. It's like there's so much to talk about, and it is fascinating stuff, and even for myself and other people out there, nobody teaches us this stuff in school, you know, and yet this is the basic planning stuff that you need in life, because
you know what, you don't, unless you go to law school and you practice in the area, you don't get to know this stuff.
That's right.
I mean, public school systems they're not law faculties. I'm not blaming anybody. It just is what it is. They can't start teaching this.
No,
it's advanced stuff, and it can only come from somebody who has a legal background.
Yeah.
So how would we deal with this? And the answer is that you get a lot of people, especially ones who are young, and they're healthy, and they don't see any problems coming. And often, as people get older, they get more cautious, and they often will ask more questions, saying, "What about this and what about that?"
Yeah.
And they'll use lawyers in the way that they should use lawyers.
Yeah.
A lot of young people, I think, they think they're invincible. I'm watching these COVID numbers. Now it's 20 to 40 or something. The ones who are tired of being locked in their house, who isn't, and they all want to party and breathe on one another, right? Well, hey, you know what? Guess what? The numbers are going up. Surprise, surprise.
And guys, even if COVID doesn't get you, we all know there's other stuff
there's other stuff out there.
There's a lot of other stuff out there, and my audience knows what I'm talking about. So it's important to have this kind of planning in place. Don't wait till God forbid it's too late.
Don't wait for disaster.
Exactly. So with that said, Jack, if my audience wants to have an idea, you know, if they wanted to put together a will, let's say we're talking about somebody who has a pretty standard situation. Maybe they may or may not own their principal residence, but maybe they have some minor children. They just want to protect the family, protect each other if they're married or in a common law relationship. What kind of investment are they looking at in terms of putting together the will and the powers of attorney for, you know, your average couple? We're not talking more advanced situations.
No, more advanced stuff is more time. It's a different story. But what I called your ma and pa will. Yeah. I usually build, depending on, you know, a few extra additions, $350, $375 per will, plus the HST that has to go to Ottawa. Yeah. And I charge $50 for each power of attorney. So each person does two, healthcare and property, so it's 100, and the other, you know, the ma and the pa, the other 100. So $200 for the powers of attorney, and whatever the math is for the wills, $350, $75 plus the tax.
I actually think, thank you, Jack. And I want to say, you know, based on my own experience, Jack, that's actually very, very decent and reasonable to get professional legal advice in drafting these documents, because people may say, oh, you know, I'll do it myself. Well, my dear.
Well, but you don't know what you're leaving out, and you don't know if what you're putting in works properly. That's okay. That's my house phone. So.
That's okay. So no, and again, and other lawyers will charge you hourly rate to put everything together. Yeah. So the fact that Jack is willing to, at least for your basic package, do like a flat rate for your typical ma and pa scenario, I think that's actually very generous of you, Jack. So thank you for that.
You know what, I was very fortunate that I built a really good practice over 43 years. I sold well, and I retired well. And my wife was very, very good with finance. We both are, but she's sort of the one watching it. And I said, once I'm retired and I'm not driven by the need to make money anymore, it's a way of giving something back, you know? So I could charge more, and I know that I'm probably coming in under the average.
Well, I don't know if it's again,
but, you know,
it's a worse scenario if people have to pay hourly rate even for a basic will, and which is
that's pretty hard. I mean, that is there was one lawyer who I'm friendly with who was charging $700 per will.
Oh, and, it can be.
And I asked him, I said, are you getting a lot of traffic at that rate? Because most of the other guys I knew our age, we're all the same age, we're all 65, 70, whatever. Yeah. Most of the guys that I know are not charging that. He said, no, it's not too busy. Well, I didn't want to make him feel badly, but maybe his fees were the reason he's not too busy.
Well, again, you've got a young family.
I didn't want to rub it in.
Yeah,
but,
especially
700 per will, so that's like 1,400 plus tax. And I think he said he was 250 for a power of attorney. It's 4 pages of paper, and most of it is left blank, and you got the top part and the bottom part, and it takes like 5 minutes to do.
It's like dentists, Jack. You know, some dentists, like I remember I had a dentist once, like looked at my mouth for 2 minutes, did nothing other than look in my mouth. That was a $200 fee. Okay, so I go to a different dentist now. Okay, because that's right. But you know, so thanks again, Jack. So everyone, that's Jack's contact info. If you wish to reach out, again, if you're in Ontario, Jack will definitely be able to help you. If you're in a different province, you may know somebody else that can help, or, you know, I don't claim to have lawyer contacts in other provinces, but Jack may have probably more.
Yeah, my contacts are really here, not other provinces.
Okay, there you go. Okay, well, but at least you know what to look out for, even if you do live in a different province. Now, Jack, what I'm going to do is I'm going to stop sharing our screen. I'm going to see if anybody asked any questions on Facebook, okay? Because we were live on Facebook. I'm just going to see if there were any questions, and I should have mentioned to people that they, you know, I don't see any questions there. Let me actually do a refresh. Sometimes people ask questions as we're going.
I hope I didn't tire them out with all that stuff. That wasn't the intention.
No. You know what?
We covered a lot of ground, you know.
We did, and thank you so much for your expertise and all your insights. What I find happens is, okay, you know what? My live stream is not even showing now. You know what, Jack? If there were any questions, I don't see any questions right now. I'll let you know if there's anything.
Okay, no problem.
So thank you again. I think we're going to wrap it up.
Okay, and then we'll be in touch when you want to do the next one so that I can prepare it.
Absolutely, sometime in the fall, most likely.
Yeah,
Jack.
that's fine.
Absolutely.
Give myself a little bit of a breather.
Oh my gosh! Well, again, you had to.
Well, you know what? The actual writing of what I did, you didn't see it. At first, I wrote it up as if I was giving a lecture, and then I looked at it because I've done webinars where I'm a participant, not the giver, right? Yeah. And I said, this is not going to work. She's going to need slides, right? And I've seen them. So I basically took the details